persons, you have given this allotment, this land to the somebody third persons, and he has cultivated this plants in your field. It's your duty, in which position he has to inform this to the government or the public, the police officers. And if you are not informed, that also it is liable. Not only that, if any company, like company is also the legal entity.
Yes.
If any company is involved in manufacturing production of this contrabands, the company, the directors and all persons who are in charge and responsible day-to-day functions of the company are also liable.
They are also liable.
Unless this production should be for the medical purpose. And the prior sanction is to be there.
From the government. So is there a specific notification from the government?
The law act itself says that if you want to produce this for the medical purpose, you have to get sanction from the government.
So that sanction is easily granted from, or there are some key...
No, the sanction is depend upon what is your purpose. The sanction you have to talk to your plant, they will check your compliance of document, then only you will get the sanction.
And sir, how is the quantity of drug calculated or the contraband calculated, especially when it is mixed with other substances?
Right. Generally what happens that whenever the information has been received regarding the contraband, the exact procedure is that when raid has been conducted by the police officers. So, for example, if there is factory in the production of contrabands without the prior permissions, so entirely they went there, they have to seal that there, they have to draw the samples, and they have to send it to the chemical laboratory. That is the designated chemical laboratories are there. And after getting the report that whether this contraband is real contraband, like EMD, the contents of EMD must be there. Because police officers are laymen, they are not technically expert. Even the government has provided them the detection kit, the contraband detection kit. Every narcotics department has this one. They brought these kits along with them. They tested, but there is a certain chemical reaction, change in that color would confirm there is a, from that we can draw the inference it is a contraband. But this evidence is not admissible. This contraband, one sample, because suppose there is 1 kg of contraband, it is not required that every quantity is to be sent to the chemical laboratory. It is not expected, or it is not easy.
Some quantity.
We have to draw the sample, right? That sample is to be sent to the CA, that is chemical analyzer. And after conducting certain tests on that, the CA confirms that it is a contraband. And what is the requirement if there are certain raw materials, but exact quantity, that is called as purity, it is 90% pure, 10% pure, 20% pure, that purity is to be taken into consideration. Because suppose the contraband is 90% pure, and if the 90% falls to the simple quantity, it is, if it falls to the intermediate quantity, it is the intermediate quantity. If it is a commercial quantity, 90% is commercial quantity. This action shall be applied and the punishment is provided accordingly. So it is ultimately depend upon the CA, because the police officers are not really known about the how to detect this contraband. These are the only the kids by they changing the color of the by that substance, but that is not admissible evidence.
So the pure
This is called as primary test.
Primary
but
test.
the ultimate conformity test is a CA test.
And sir, can you provide us with like specific provisions and penalties for different kind of drugs like cocaine or MD or ganja under NDPS?
So there are from section 50 onwards, section 27, 30, all provisions are there. Separate provisions for cannabis plant, separate provisions for the coca plant, and also separate provisions for the coffee store. Above that, the other contrabands like EMD, LCD, there are also separate provisions for that. But whenever any provisions is there, it depends upon your commercial quantity, small quantity, and it is an intermediate quantity. And punishment is 1 year if it is small quantity. For the consumption, it is only 6 months punishment. But storage, selling out, trafficking, there are several provisions are there. But it is punishment is always depends upon the quantity.
Sir, as we all know that cannabis is used in medical treatment. So, what is the legal status of cannabis?
Cannabis is like a plant.
Yes.
Right. So from the flower of that, they prepare the ganja. From the leaves, there is also another products, and from the resins, like a liquid substance. Like from the hashish, and also there are several drugs is to be prepared from the plant. But whenever there is a cannabis tree is there, it is used in a medical purpose also. But when suppose, for example, any persons cultivated large quantity, commercial quantity, and for that purpose he used in trafficking of that cannabis, it is not expected like that. If it is a permitted for the medical purpose, then it is only for that purpose only.
So, from your experience, what are the common loopholes or procedural defects in this NDPS Act?
So there are several provisions relating to the NDPS Act. But as a defense lawyer, we have to concentrate on the section 41, section 42, 43, right? Section 50, 52, 52A and 57. As earlier I have stated, whenever there is secret information has been received, so that has to be registered down. There is a register. Then after search warrant, any persons authorized, any persons can search. Each person should be authorized. So there is a list of authorized persons. They have only the search. They have right to search. So we have to cross-examine that point whether this person has authorized the person, is there any search and seizures, they have powers, and so far as the personal search is considered. See, section 50 is applicable only to your personal search, belonging, pockets. If you are carrying a bag, and there is no section 50 is applicable. If you are traveling with the vehicle in a vehicle and search of vehicle, search of house, there is section 50 is not applicable. Only for the personal search. And there are 5 sub-clauses section 51, out of which the main clause is that. Because generally what happens that there is the apprehension that police might have planted these contrabands into the pockets of the persons and the innocent persons would have been falsely paid. To eliminate this possibility, this is the provisions of section 50 has been incorporated in this section incorporated. And this section 50 provides that whenever there is a personal search, so person who is going to search these persons, that is suspected persons, he has to apprise the right of the accused person that you are right that your search should be in presence before the gazetted official supervisor. So this appraisal must be there. This is not a mere empty formality. Now recent Supreme Court judgments are this oral appraisal not to be written. It should be written, and not only that, Supreme Court goes beyond that. It should be apprised in a language which is known by the accused person. So it is a vernacular language of the accused person. It is not a mere formality. And if that has not been complied, then entire search becomes invalidated, futile, exercises futile, and definitely the persons would have been acquitted.
So, how inconsistencies or irregularities in search or complete procedures of search and seizure of contraband lead to acquittal? So how does
what happens? This compliance is there also. But there is section 44 under the NDPS Act. It says that not only these provisions of NDPS Act, but the provisions of the CRPs relating to personal search, right? House search, section 100 of the CRPC, earlier CRPC, are also applicable. Unless and until these provisions are contrary to the CRPC, the CRP provisions are applicable. They are in consonance with the NDPS still. So we have to we have to see whether this compliance of this house search and personal search has been as per the sections 100 and there. For example, any information has been supplied to the police officer that in one house such a contraband has been manufactured, or any persons has been having possessions of the contraband. he has stored this contrabands in a house. So far as the house search is considered, CRP 100 is there.
Yes.
So the accused has the right to search the police also. They have to, this search is to be carried out in front of the independent counsel. If these provisions have not been complied, then definitely it would be benefit and leads to the acquittal of the accused person. So we have to see as a defense lawyer whether these provisions are also complied or not in the charge sheet.
So procedural safeguards of section 42, 50, 52 of NDPS sometimes.
And these are not merely directory, these are mandatory provisions. And if this violated, definitely leads to the acquittal because these are mandatory. Supreme Court time and again says that these compliance are not empty formality. These are mandatory incumbent upon the IO.
Okay. Sir, we'll come to the end of the video. So recently Aryan Khan's case and Riya Chakrabarti's case have been widely publicized. So can you explain the legal arguments that led to their acquittal or bail?
See, there is sections of 29. It says that if there is a criminal conspiracy, suppose he is a person who brought the contraband, he is going to sell, he has financially aided this person, so there is a conspiracy. But in this case, Riya Chakrabarti and also Aryan Khan's case, the quantity is small quantity. And there are certain WhatsApp chat, messages, and then money transactions are there. But the IO has not successfully got into the notice of the court that these transactions only for the purpose of drug trafficking, and there is no there are tells to that conspiracy, because if there is transactions between A and B, money transactions. Now, how can I draw an inference? It is only for the procuring of the crime. There are also WhatsApp charts are there, but if these charts are not relating to that drug trafficking, so it cannot be considered as a conspiracy. And on that basis, if it is small quantity, that quantity is a single person's quantity is to be taken into consideration, and there is no one, then definitely persons will be get bail and also he will be acquitted. Now, so far as the sampling is considered also, not only seizing. Right? Seizure is there, but so far as the sampling is there, I have already narrated you that. Whenever the raid has been conducted, certain contrabands has been found in a large quantity. This sampling drawing is also important aspects, because possibility to rule out that this contrabands has been tampered by sending the sample quantity to the CA. And for that there is also possible safeguard. The narcotic department, excise department, central government, state government, time to time issue the circulations. There is also SOP standard operating procedures for that, and there are several provide certain guidelines by the Supreme Court and Honorable High Court also. So the IO must keep in mind that they have to adhere to the SOP, they have to adhere to the guidelines which is issued by the Supreme Court, and any violations of these guidelines or any conditions or any SOPs, so it leads to the doubt in the mind of the court, and definitely there is the benefit of doubt goes to the accused person. So far as sampling is considered, generally, for example, a person's found a contraband, like for example, MDPS in his pocket. So then, when this person has been arrested, booked, and brought to the police station, the contrabands have been seized by the Panchanama before the independent person. Now, this all article is to be sent to the police machinery in their Madhyapal room. They have to safely keep this storage. And not only that, immediately they have to store in the Madhyapal room, and not only that, then after this, all the materials, they have to tag this all the materials, right? Tagging there, number is there, serial number is there, all materials is to be sent to the magistrate as soon as possible. And inventory is to be done by the magistrate, section 52A. Inventory means what? The magistrate, that is judicial magistrate, verify all these things, that what samples have been drawn, how much quantity is there, whether they are serial number or not, whether the seal is intact or not, and upon that the magistrate himself draw the samples. And now the circular guidelines and the the law says that, not law, but the citation says that two samples is to be drawn, because one in original, one another is duplicate form. Two samples is to be drawn, and for every contravance, different quantity prescribes. That is threshold frequency, threshold quantity. That, for example, if it is a powder content, and if it is a 100 gram powder has been found, out of 5 gram is a minimum quantity is to be taken from the sample. If it is below that, then definitely is contraventions of the guideline. So for the ganja, there is different provisions. For cannabis plants, there is a different quantity, sample quantity. For the powders, it is a 5 gram quantity, and below that, the sample quantity is not allowed.
So, as you said that there are punch witnesses during the whole investigation by police department. So
Nowadays, what happens that there is circular on behalf of the government that generally the persons who acted as a government servant should act as a independent, because these persons are independent persons. Normally, the police issues letter to the government department, and the persons who is employed with the government acted as a punch witness. But normally, it is a public place, right? So it is expected that the persons who are gathered, who are there, they should be acted as independent persons. And it is also that stock panchas should be avoided, because if the stock panchas are there, so it creates doubt about the panchanama, and the court will get the benefit of it.
So the punches are influenced by the police.
Police will not be applicable in these cases, because if these are the stock habitual panchas, so court will not believe on them. If suppose the raid has been conducted on the public place, like in a park, suppose for example information has been received and persons from the park having the contraband, so the persons are available in the park. So why you are not taking this person as a punch witness? They are independent, natural person, they are present over there. Why you are not taking them as a punch? In spite of that, you take your habitual punchas and prepare the panchanama. And if these are habitual punchas, it creates our doubt about your panchanama.
So just to ease the investigation or to take case on their side, it is a common practice.
Common practice.
Okay, so sir, let's talk about the recent rave party case in Pune involving Dr. Pranjal Khewalkar, and as we all know, you have been advocate in that case.
No, what happens, that matter is pending, so I cannot comment, because wait for the decision of the court. But generally, now recently the MCR has been, after practice persons are taken in MCR, we are going to apply for the bail. And I am not representing the Dr. Pranjal, I am representing one of the accused. We will discuss with the other advocates and we will fight the bail.
So, just a normal question, does this case have some political influence, and how a lawyer or a practicing advocate can prove or defend against such false and frivolous claims as we have all seen?
No, the rivalry, this person has been falsely implicated. This is one of the defense of the every advocate or every accused person. But here, making any defense does not serve the purpose. You should have certain substantial evidence beyond that. Why you have been falsely implicated? Suppose the persons, the complainant has any rivalry with you, the opposite party has a rivalry with you, and for that purpose you have been falsely implicated, so you have to brought onto the record. But if you have taken the false defense, then definitely it goes against you.
Okay, and sir, what about the political influence?
In each and every cases there is no political influence. If a political person involved as an accused person, then definitely might be there is a political pressure. Like a common persons found in a park having a contraband, there is no political influence. If an accused person is related to the political, then only we can say that some persons who are opposite other persons due to the political rivalry has been implicated. Common persons are not related to the political party. Each and every cases there is no political influence. But political influence and